Miss Francois, I hope you're doing well.
Thank you, I am.
Good.
You ready to start, Judge Morrow?
Well, whenever you all are ready, we're ready.
All right, there you go, see this. Come on here.
Yeah, you can see.
Fellas, you know.
Good morning. We're going to be starting with positions 3 and 4. Mr. Caldwell.
Okay, thank you. And this is going to be an arraignment.
Good morning, Your Honor.
Good morning. And
Yes, Mr. Caldwell, I believe, is one of our probation cases, Judge.
okay, I was
Yes.
Yes. He is
okay.
Position 3 and
3 and 4 on the probation revocation calendar. Let's see, do we have anyone on from probation? I don't think we have anyone on from probation as of yet. Would you all like to go to someone else while we wait?
Yes, that's fine. Positions 4 and 5, Mr. Barbers.
And Mr. Barbers is going to be an arraignment and a bond modification request, correct?
Yes, Your Honor.
Good morning, Mr. Barbers. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, Mr. Amaro. How you doing, sir?
I'm doing well, Mr. Barbers. Do you agree to have your case heard by video this morning?
Sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down, Mr. Barbers. You've been charged in case 22 CR 005590F with loitering and prowling and obstruction of a law enforcement officer, and in case 23 TA with a failure to appear. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
Yes, Your Honor.
How do you plead, Mr. Barbers? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. I take it that that Mr. Barbers missed a court date. Is that right?
No mail, sir.
Yes, Your Honor. I'll try to get that court date for you. I believe it was, I'll try to get that court date for you.
Okay. Good morning, Mr. Peelan. I need the court date because if he did miss someone's court date, another division judge, and they issued this bond, then my normal course of practice is to return it to the division judge.
Understood, Your Honor. Your Honor, that court date was April 25th with Judge Richardson. It's a plea and arraignment.
Okay. Ms. Adams, my normal course is that I return these cases to the division judge if they have issued the bonds.
1 second, Your Honor. Your Honor, with regards to that, I just was speaking with Mr. Barbers and he has opted to, change his plea. I have, found that he has been incarcerated for 209 days. The offer that was given by the state was 12 months to serve, 365 days. I think, that should probably get him home today, if I'm not mistaken.
This is a time served plea offer. Is that correct, Mr. Pilon?
Your Honor, I said the offer was, yes, sir, 12 months to serve, 365, credit for time served, 365.
Your Honor, with regards to that, we're gonna go ahead and, change his plea. If you don't mind, can we, come back to him? I have to go over the plea paperwork with him. And it's
Okay.
not gonna take very long.
That's fine with me, Ms. Adams. We'll be back with you, Mr. Barbers.
Yes, sir.
Mr. Gilmore is the private attorney, position 10.
Gilliam.
Okay, good morning, Mr. Gilliam. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Good morning, Ms. Gore. What are we doing with Mr. Gilliam this morning?
Good morning, Your Honor. My understanding is that he was picked up on a bench warrant
Okay,
in Gwinnett County and transported. We just got information about this hearing on last night. My goal is to petition the court for his release on his own recognizance this morning, Your Honor.
all right. Where are we with this, Mr. Pilon?
As far as why he's appearing in front of the court today, Your Honor?
Yes, I don't see my calendar only shows the charges. They're back from 2017. There is no, that
Yes, Your Honor. I showed that he failed to appear at a jury trial on August 9th of last year, and that his bond was forfeited January 10th of this year.
And Your Honor, if I may, I'm not certain if you have access to the clerk of court site, but about 8 weeks ago, we connected with the client and realized that the court had been serving the wrong address. So as a result of that, again, about 8 weeks ago, we filed a motion to lift the bench warrant, and we included proof where the clerk of court was serving the wrong address. That stated, yes, Mr. Gilliam did miss court dates, but it wasn't out of disrespect or him simply not showing up. He was never notified through his counsel of record. And again, in those motions, we showed proof where the clerk of court was missing the suite number and building number, which is important part of the address. And we show where they also was receiving return to sender. And we tried to get this matter rectified 8 weeks ago. We called the clerk. We contacted various litigation managers. We've got a string of emails and no one wanted to help. So then when the client was arrested because he was walking down the street in Gwinnett, he got held and has been held for 2 weeks on this matter, which again, we believe that a bench warrant should have never been issued because there was improper service or ineffective service.
Do we have the does the clerk have the correct address on file at the present time, Ms. Gore?
Your Honor, my understanding is they've always had it because we also attached the document where we changed the address, but are they using the updated address? I have no idea.
Okay, I just want to make sure that we do have it in our system. Would you mind placing the proper address in the chat for me?
Yes, sir.
To Ms. Casey Strong. And that way we can check to make sure that we do have the correct address in the system. Do we have his previous bond?
I'm looking for that now, Your Honor. That took me a moment to realize that was a question for me. So Your Honor, what I see is that he had a $2,500 SOB through pretrial on the first simple battery charge, and then $1,000 surety bond on each subsequent charge. So $2,000 surety, $2,500 pretrial release.
And do you also have, so Miss Gory, what I am going to do is I am going to give him a signature bond through the jail. Mr. Pilon, what were the conditions on that bond previously?
Two sheets of paper. I don't put anything in the subject line, I'm just sending it back. Just it said. Thank you.
Your Honor, if Your Honor would give me a moment, I'm getting some conflicting information about the type and the amount between my Odyssey screen and the jailing screen.
Okay.
Good morning, Your Honor. How are
Good
you?
morning, Mr. Walker.
So I have the bond order pulled up. It was one of the pre-filled bond orders. All of the boxes are checked. So the conditions were defendant shall not violate any further laws or ordinances. No contact with the victim. It looks like the victim's name was Joseph Paul.
Joseph Hall.
Paul, Paul, I believe.
Okay.
No weapons. And all the other boxes were checked. So
Was there a stay away listed?
there is not an address. It's just a no further contact.
Okay. So, Ms. Goring, it's the court's practice to have the person seeking the bond modification to prepare it for the court. So if you could do that, it'll be $1,000 signature bond on each charge through the jail. No further contact with Joseph Paul, and no drugs, alcohol, weapons while out on bond.
Yes, Your Honor, no problem. We'll get that drafted up and sent in today. This is my first time appearing before Your Honor, so I apologize for my questions. Do you know about the timeline for release for defendants?
Well, as soon as you get the order to Ms. Strong, she'll get it to me. I'll get it signed. We'll get it to the jail, and the jail, if he doesn't have anything else holding him, we'll process him out. So he should be out in the next 24 hours.
Wonderful. I'll get to typing right away.
Okay. All right. Anything
Your
further?
Honor. No, sir. Am I excused?
Yes. You have a good day. And
Likewise.
good luck to you, Mr. Gilliam.
All right, thank you.
Thank you, sir.
Thank you.
Section number 9, Mr. Marlon Gresham.
Can I find it?
This is going to be a negotiated plea.
Yes, Your Honor, one moment, please. Just getting paperwork, okay. Yes, Your Honor, I'm ready.
Mr. Walker.
Yes, Your Honor.
I have a victim, she says, of a car accident. She says that someone in your office asked her to be here in G33 this morning. She doesn't know the name of the person that she spoke with or the name of the person that allegedly hit her. Is there any way that we can send her to your office or have someone figure out where she's supposed to be? She's saying that someone from your office told her to be in G33 this morning.
Is there any way we can get her phone number? I can maybe reach out to her, or is there anybody in G33?
I'm in G33.
Oh, is it possible that we can put her number in the chat? I can give her a call and try to figure it out.
Okay, thank you. I appreciate it. And the court's ready to proceed whenever everyone else is.
Defense is ready.
Miss Ivy, Felicia Ivy.
It's position number 9.
Okay, and are we ready with this, Ms. Adams?
Yes, Your Honor, we are.
Okay, good morning, Mr. Gresham. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Your Honor, good morning.
Good morning, sir. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, Mr. Gresham. Mr. Pilon?
Okay.
Under state's recommendation is time served, balance suspended, a stay away from all MARTA locations.
Do we know how much time he served?
I can pull that for Your Honor.
Your Honor, I show that he served about 15 days.
Okay,
And although it says stay away from MARTA, one of the issues that he has is that Mr. Gresham works, he has a job. And he also has a medical condition. And so he's gonna need to get to Grady and also to work from time to time. He doesn't have another way of getting there because he cannot afford to take Ubers and cabs and get rides. And so with regards to the suspension, it shows that the suspension actually expired in March, or of the MARTA suspension already expired in March. And so with regards to that, Your Honor, I was wanted to request a modification with regards to the stay away order for MARTA.
you, Mr. Pilon?
Your Honor, so I'd like to pull the case file just to confirm this, but I have in my notes that this defendant actually committed the same offense at the same location on August 22nd. And at that time, he had an active MARTA ban. So I don't know what the basis of defense counsel's information is.
Sure. I can tell you exactly where I found it to make it easier for you, Mr. Pilon.
That would help.
One moment.
Okay, I think what the court's it's gonna be 12 months to serve, 15 days, credit for time served, 15 days, balance suspended, and abide by any active MARTA suspensions.
Okay, thank you, Your Honor. The one where I found it, Mr. Pilon, in the affidavit for arrest, in the probable cause portion, at the very bottom, it says expires 3/20/23.
Okay, I understand that. My concern is because this defendant has a subsequent case, I believe because of this case, that stay away was extended. And then he violated that again at the same location because the subsequent case is an incident date of 8/22.
I do have that case number, but what I do not have is what the expiration date is.
But what you're gonna have to do, you all, Ms. Adams, is that you're gonna have to make sure that he doesn't have any active MARTA suspensions, because if he does and he goes back there, then he's gonna be in violation of those suspensions.
Yes, Your Honor.
As far as today goes, he's gonna have to make sure that he doesn't have anything active. If he does not have anything active, then he can go back there. If he does have something active, then he's going to have to wait until they're lifted.
Yes, Your Honor.
Is that agreeable?
Yes, Your Honor. Mr. Gresham, I will try to find out, when that expires, okay?
Okay, and just make sure that if he gets out, that he doesn't go back there until you all clear up whether or not he can be back in MARTA.
Yes, Your Honor.
All right. Mr. Gresham, it's my understanding, if there's nothing further, anything further, Ms. Adams?
Not at this time, Your Honor.
Okay, Mr. Gresham, it's my understanding that in case 23 CR 0008548, you wish to plead guilty to fair evasion and criminal trespass. Is that correct?
That is correct, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, I'm not.
You've been represented by counsel. Are you satisfied with her representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I do.
Has anyone forced or coerced you to plead guilty?
Yes.
Nobody's forced you to plead guilty,
Oh,
have they, Mr.?
I'm sorry. I'm sorry, Your Honor. I didn't hear you.
Okay.
No one has forced me to plead guilty, Your Honor.
All right, very good, Mr. Gresham. I'll accept the plea as negotiated. You know, you can only go back to MARTA if you don't have an active suspension. So make sure that that you don't have an active suspension and you can go back there, okay?
Yes, sir. Your Honor, could I go to security at MARTA precinct?
Speak to Ms. Adams about that, Mr. Gresham, and she'll be able to advise you, okay?
Yes.
All right, thank you, sir. Good luck to you.
Yes, sir.
Position 6 and 7, Mr. Canty.
And these are going to be negotiated, please.
That's my understanding, Your Honor.
Believe so, Your Honor.
Good morning, Mr. Canty. Can you hear me okay?
Yeah.
I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, Mr. Canty. Yes, Mr. Pilon.
Your Honor, state's recommendation in position 6 is 12 months to serve 30 days, balance probated, credit for time served 15 days, stay away from the incident location. The recommendation for position 7 is 12 months to serve 50 days, credit for time served 25 days, balance probated, family violence intervention program, no further contact, and a stay away from the incident location.
Okay, do we have for both cases the incident locations?
I'm pulling those for Your Honor now.
While he's doing that, Ms. Adams. Anything from you regarding this?
No, Your Honor, we just asked that the court accept the negotiated plea. The time that he had served on both of them, based on the 2-for-1 given out by Fulton County Jail, he should be being released today.
$15.45 here
For which one?
for position number 6.
Do we have 7?
I have it now, Your Honor. For 7, it's 3804 Martin Luther King Jr. Drive.
Okay. And for position 6, Mr. Pilon, is there any reason that can't be balance suspended?
No, Your Honor. I don't know why it wasn't worded like that already.
Okay.
Also, Your Honor, for the position 7, the no further contact is Miss Alexia Slayton.
Okay, thank you. Mr. Canty, it's my understanding that in case 23 CR 005128G, you wish to plead guilty to criminal trespass, and in case 21 CR 003274G, you wish to plead guilty to battery family violence. Is that correct?
That's correct, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the pleas as negotiated. For position number 6, the balance is going to be suspended, but you stay away from that Mansell Road address. And in position number 7, when you complete the terms of the probation, I'm going to have it go to a non-reporting status. So the sooner that you complete the FVIP, the sooner that you won't have to report to probation or pay those fees, okay?
Okay.
All right, good luck to you, Mr. Canty.
All right.
This number 14 and 15, Mr. James Caesar.
Yeah, today.
And this is going to be an arraignment.
Yes, James Caesar, position 14
Yes.
and 15. No, yes, this is gonna be not guilty in a bond hearing, Your Honor.
Okay. Good morning, Mr. James. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Can you unmute for no?
Good morning, sir. Yes, sir, I do.
Good morning, Mr. James. Thank you. Let's see, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Mr. James, you, in case 23 CR 003053H, you've been charged with simple battery, criminal trespass, and reckless conduct. Each of these charges carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
Yes, Your Honor.
How do you plead, Mr. James? Guilty or not guilty?
Not guilty, sir.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Mr. Pilon, did he miss a court date? And if he did, whom did he miss it with?
Your Honor, I don't. Here we go. On July 21st, 2023, he missed an arraignment date with Judge Taylor.
Okay. And Ms. Adams, is there any reason that what I normally do in these cases is send it back to the division judge for them to, if they've given him a bond, for them to modify that bond? Is there any reason I should not do that in this case?
Your Honor, yes, Your Honor. With regards to Mr. Caesar, this is the very first FTA. He'd moved. Actually, no, he didn't move. What happened with him was he had actually been arrested, and when he got out, he lost everything, including being evicted. He was staying at people's houses. He wasn't allowed to receive mail at those places. So when the notice went out, he had not received it. He had since updated his address. And when he found out that he had missed court, he actually attempted to try to, have it reset. But instead they came and arrested him rather than giving him a chance to get his bench warrant set aside. Additionally, Your Honor, Mr. Caesar has absolutely no contact with the complaining witness in this case. He's born right here in Georgia, raised in Atlanta. He lives out in Lithonia. Most of his family is here. He does have a job. He's gainfully employed. He's got some college education. And yes, Your Honor, we're just requesting that the FTA be set aside. He's been in jail for 25 days.
What was the bond? What was the previous bond before he missed the court date?
$7,500.
Surety bond, Your Honor. Your Honor, state would just reassert its defendant's responsibility. He had counsel's phone number. He could have called to check the dates. He did not do so.
Unfortunately, Mr. Pilon, he did not have counsel's phone number because when he got, he was homeless. So he went from staying in people's houses to staying under bridges.
I just want to clarify that the public defender's office phone number is not advertised.
It is out there, but he didn't have a way to, so he didn't recognize because it was arraignment. So he knew he was arrested. He didn't know he was represented by counsel at that time.
Okay.
So once he was arrested, once he figured all of this out, he tried to rectify it. As soon as he knew he had a bench warrant, he tried to rectify it.
And what is the current bond?
It's the same, Your Honor, that 7,500.
The 7,500 is the bond. It was the bond amount on his case, Your Honor. The FTA has a $10,000 bond on it.
Okay. Again, I'm going to send this back to the division judge who issued the bond and let and if they decide that they would like to modify it, I'll let that judge modify it. Good luck to you, Mr. James.
Thank you, Your Honor.
Positions 22 and 23, Mr. Miles.
It's Blunt.
Yep.
You get a chance, call Derek Howard, please.
And this is also going to be an arraignment and bond modification.
Yes, Your Honor.
Yes, good morning, Mr. Miles. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Good morning, sir. Can you raise your right hand for me?
Yes, sir.
Swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down. Thank you, Mr. Miles. You've been charged in case 23 CR 002655H with 2 counts of cruelty to animals, 2 counts of tethering, 2 counts of no proof of current rabies vaccination, and 2 counts of no Fulton County license tag. Each of these charges carries with it a maximum penalty of 12 months in jail and to $1,000 fine. Do you waive formal reading of the accusation? Ms. Adams?
Yes, Your Honor.
How do you plead, Mr. Miles? Guilty or not guilty?
I think we'll be a plea option. Guilty.
It was my understanding that you were going to plead not guilty. Mr. Miles, I'm happy to let you talk with Ms. Adams regarding that if you would like to. Ms. Adams?
Mr. Miles, talk about you want me to do that?
I'm sorry, I couldn't understand you, so I don't know if Mr. Miles can understand that.
Mr. Miles, can you hear me okay? Can you guys hear me okay now?
Yes, ma'am.
Mr. Miles, when you and I spoke yesterday, that's the possibility of attempting to get a signature bond. Do you still want me to try that? Change your mind and decide to go ahead and take a plea.
Oh, you go ahead and take the plea, ma'am.
Okay, Your Honor, then he changes his plea to guilty and we are prepared to move forward.
Okay. Has he completed the paperwork?
Yes, Your Honor.
Okay. Yes, Mr. Walker?
Yes, Your Honor. 1 second, switch gears. The state's recommendation is going to be 12 months to serve, 78 days. Credit for time served, 39 days. Balance probated with the condition of completing a BART class, that is an online animal cruelty course, and no animals while on probation. And then we will be null pricing position 23 in exchange for the plea in 22.
Okay, Ms. Adams?
Your Honor, we just ask the court accept the plea number 2.
Okay. Mr. Miles, it's my understanding that in case 23 CR 002655H, you wish to plead guilty to 2 counts of cruelty to animals, 2 counts of tethering, 2 counts of no proof of current rabies vaccination, and 2 counts of no Fulton County license tag. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and if by pleading guilty to them, you're giving up your right to a trial by jury?
So, I say.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
Okay, I'll accept the plea as negotiated. Mr. Miles, let's see, as soon as you finish the BART class, the probation is gonna go non-reporting. So the sooner you get it done, the sooner you don't have to report the probation and the sooner that you don't have to pay those fees, okay?
Yes, sir.
All right, good luck to you, Mr. Miles.
Thanks.
Position number 16 through 19, Mr. Jones.
Say it again, I'm sorry.
16:16 through 19.
And this is going to be a negotiated plea,
The position 16, Your Honor.
16, 17, 18, and 19.
Yes, Your Honor, it's gonna be negotiated.
Okay. Yes, good morning, Mr. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, Your Honor.
Thank you. Can you raise your right hand for me, Mr. Jones? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Okay, thank you. You can put your hand down, Mr. Jones. Yes, Mr. Peeline?
Your Honor, I'd just like to clarify with Mr. Walker, I have that no offer was conveyed for position 19.
That is what it says on the sheet. I was actually gonna ask the state whether or not they, it was, if there was no plea. Now that there's a plea, I was gonna ask whether or not it can just be concurrent.
I'm not sure what defense, so state's position is that if he pleads to position 18, then position 19 will become a felony.
That is correct, Your Honor. As we all know, your second battery family violence is a felony.
So we could easily handle at least, I guess, 16 and 18.
Do you still want to proceed?
I think you probably need to speak with him at a later time, Ms. Adams, to what that's going to mean for him in that regard. So if you, and I don't think it'll be something that you'd be able to do today. If you want to place it back on a calendar next week, we can
Yeah.
do that.
He and I discussed it, Your Honor. It's just, I just want to know whether or not he still wants to move forward, knowing the other case will go up as a felony. If not, then we can discuss it later.
Ms. Adams, just reset it, so we have more time to really delve into that. So
Okay.
if we can reset this to next Tuesday's calendar, that'd be great.
Okay, thank you, Mr. Howard. I think that'd be best. So, so that's the 12th. We'll reset Mr. Jones until 9/12. Okay, we'll see you back next week, Mr. Jones.
Position 26 and 27, Pickens.
And this is going to be a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Pickens. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, thank you. You can put your hand down, Mr. Pickens. Yes, Mr. Walker.
Yes, Your Honor. The state's recommendation is going to be 12 months to serve, 44 days, credit for time served, 22 days, balance probated with the conditions of a 6-week anger management course, no further contact with the victim, whose name is Christopher Walker, and to stay away from the incident location. If I could have one moment, I could tell the court the incident location.
Okay.
And while Mr. Walker is looking for that, Your Honor, Mr. Pickens' ability to stay away and have no contact should not be a problem, as he and his family have since moved from that area. And it was an issue between children.
Okay.
Your Honor, we could just leave it with no further contact with the victim. That's sufficient.
Okay. Mr. Pickens, it's my understanding that in case 19 CR 007867J, you wish to plead guilty to battery substantial physical harm. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
Oh, Your Honor.
You've been represented by counsel. Are you satisfied with her representation?
Sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Oh, Your Honor.
I'll accept the plea as negotiated, Mr. Pickens. Let's see. As soon as you get the 6 weeks of anger management done, your probation will go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation and pay those fees, okay?
Yes, sir.
All right, good luck to you, Mr. Pickens.
Probation's positions 9 and 10.
Okay, good morning, Officer Harris.
Good morning, Your Honor. How you doing?
I'm doing well. I hope you're as well. This is Mr. Fair. Good morning, Mr. Fair. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Yes, Officer Harris.
Yes, Your Honor. Mr. Fair was sentenced to probation on September the 15th, 2022 to complete 8 weeks of anger management. He missed a prior hearing on July the 11th with Judge Etlon. Mr. Fair has roughly 40 days remaining on his case after we had to do how much time he has left. Probation recommendation is to time serve his case and to close it.
You don't have any objection to that, Mr. Howard?
No objection to that, Judge.
All
Close
right.
it out.
I'll accept the probation's recommendation, Mr. Fair. Time served. Good luck to you, sir. Who do we have next?
Position 36, Mr. Van Dyke.
And this is going to be a non-negotiated plea.
That is correct, Judge.
Okay. Good morning, Mr. Van Dyne. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes,
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Is that a yes? You have to be verbal for me.
Yes, sir.
All right, thank you. You can put your hand down. Let's see, who do we have from pretrial?
Man, I'm sorry, Your Honor, I stepped away. What position is this?
36, Mr. Van Dyne, non-negotiated plea is my understanding.
Okay.
Anyone on, do we have anyone on from pretrial? Do you have his history, Mr. Walker?
1 second.
And would that be, if he does have the history, Mr. Howell, is that adequate with you, or should I get someone on from pretrial?
No, it's fine if Mr. Walker gives the history.
Okay, thank you.
If we could request someone for pretrial, because this case is not coming up in Odyssey for me, but let me search for it one more way.
Okay.
So I'm showing a battery conviction, 23 CR 003749C. I believe that was in August of this year. Outside of that, I'm not showing any additional history. In this case, law enforcement responded to 970 Charles Allen Avenue. They were contacted by the homeowners because they observed 3 males, this defendant being one of those 3 males, forcing entry into the home. Upon arrival, law enforcement did make contact with the defendant inside the home. There was some cash, some drug paraphernalia that was obtained on site. At that time, the defendant was taken into custody. With that being said, the state's recommendation or the state's offer is 12 months to serve, 90 days, credit for time served, 14 days, balance probated, no further contact with the victims, Mr. and Mrs. Gross, a stay away from the incident location, which is the house that belongs to the Grosses. That's 970 Charles Allen Avenue, and 100 hours community service.
Mr. Howard?
Yes, Judge, and the only issue we have is the recommended time. It was showing 90 days recommendation on the offer we received. We're just asking that it be a time served case. Mr. Brett Van Dyne does want to put this matter behind him. We believe the amount of time he served in jail is sufficient to address the allegation of damage to property. I'm showing he's done about 18 days in custody, so I would ask the court to just time serve this case. We don't believe any additional time will be necessary given the allegations.
Does he have a place to live, Mr. Howard?
He does, Judge. Yes, he does have a place to live and everything. Yep.
Okay, if nothing further, Mr. Van Dyne, it's my understanding that in case 23 CR 005109D, you wish to plead guilty to criminal trespass, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept your guilty plea, Mr. Van Dyne. The court sentence is going to be 12 months to serve 36 days, credit for time served 18 days. The balance will be probated, no further contact with the Grosses, stay away from the Charles Allen Avenue address, 100 hours of community service. I'm gonna have you report to probation for the entire 12 months. All right. Good luck to you.
Judge, in light of that, we would ask the court if the court be willing to waive some probation fees if he's going to be required to report, if the court be willing to do that. Because I don't believe there's a rest, there isn't any issue with the property being repaired. It's my understanding that one of the other persons involved has already taken care of that. So essentially, he would just be reporting for the community services, sounds like.
Right. I want him to report to probation, given what the allegations were. I'm giving him a break on the time that he's staying in jail, and not requiring him to do that, and he'll be able to get out and hopefully get the community service done and get a job and pay for the probation fees. So yes, the court's not willing at this point to waive any of those fees for him. All right. Good luck to you, Mr. Van Dyne.
Position number 20, Honor, Mr. Jones. I'm sorry, I apologize. Position number 25, Mr. Norris.
For the record, Norris is not his correct last name. His correct last name is Barrow. Norris was a alias.
Okay. And what's the correct last name? Can you spell that?
Yes, Your Honor. Barrow. B as in boy. A-R-R-O-W.
Okay. So it's Marco Barrow.
Yes, Your Honor.
And this is going to be an arraignment and a bond hearing, is that right? Yes. Good morning, Mr. Barrow. I am Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Yeah.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Okay, you can put your hand down. Thank you, Mr. Barrow. Let's see, you've been charged in case 23 CR 005275E with theft by shoplifting and 2 counts of criminal trespass. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusations, Ms. Adams?
Yes, Your Honor.
How do you plead, Mr. Barrow? Guilty or not guilty?
Plead not guilty, Your Honor.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Let's see, what is the current bond?
Your Honor, the state will consent to a signature bond on this case for the record.
Okay,
The only condition we're asking for is to stay away from the Walmart on 344 Cleveland Avenue.
There's no objection to that, Your Honor. Also, Mr. Walker, and looking at the accusation, it appears that there are 2 criminal trespasses on Mr. Barrow, but they both are for the exact same thing. So,
I could take a look at it after court.
thank you.
okay, so it'll be $1,000 signature bond through the jail on each charge, which makes it a total of a $3,000 signature bond through the jail. Stay away from the Walmart on Cleveland Avenue, and no drugs, alcohol, weapons while out on bond. Okay, did you get that, Ms. Adams?
One more time, Your Honor.
$1,000 signature bond on each count and to stay away.
Yes, so a total of a $3,000 signature bond through the jail.
Thank you.
Okay, good luck to you, Mr. Barrow.
Yes, sir. Thank you, Your Honor.
You're welcome, sir.
This is gonna be the probation calendar, positions 1 and 2. Mr.
Okay.
Bonte.
Good morning, Mr. Bonson. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
All right, thank you. Yes, Officer Harris.
Yes, Your Honor. Mr. Barton was sentenced on March the 21st of this year to 12 months to complete a mental health evaluation. As of today, he has not reported to our office. He has 7 months, 28 days remaining. Probation recommendation is to continue him on probation and to complete the evaluation within the first 30 days upon his release.
Mr. Howard?
Judge, we will follow that recommendation.
Okay, and is he having an issue with that MHE, Mr. Howard? Is something that we can assist him with?
No, Judge, he just, now we did speak about that he needed to get that done. And I gave him the information for where he can get it done for free over on Boulevard.
Okay.
So he's aware of what he needs to do at this point, Judge.
All right, thank you, Mr. Howard. All right, I will accept probation's recommendation. Good luck to you, Mr. Bonton.
Yeah.
Your Honor, probation, calendar 13 and 14, Mrs. Stroger.
Yes, good morning, Mr. Strozier. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Yes, Officer Harris.
Yes, Your Honor. Mr. Ricky was sentenced on November the 22nd, 2022 to 12 months to complete a shoplifting course. As of today, he has not reported or completed the course. He has roughly 187 days on probation. Probation recommendation is just to time serve his case and to close it.
We'd ask the court to follow that recommendation, Judge.
All right, time served. Good luck to you, Mr. Strozier.
Good morning, Your Honor. This is the ACDC. Coming up before you is position number 5 under probation revocation, Jamia Carter.
Yes, good morning, Officer Milton.
Ms. Carter, come on up.
Good morning, Ms. Carter. I'm Judge Eric Morrow. This is the probation revocation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you, Ms. Carter. Yes, Ms. Officer Harris.
Yes, Your Honor. Ms. Carter was sentenced March 29th of 2022 to, I want to say 24 months to pay a fine of $645.50, submit a drug alcohol evaluation, risk reduction program, a victim impact panel, and 40 hours of community service. As of today, Ms. Carter has not provided us proof of any of those conditions. She has 54 days remaining on her case. Probation recommendation is to revoke the remaining balance.
Mr. Howard.
Judge, we're fine if it means revoke the balance and commute it to time served. The recommendation I got was to revoke 30 days. She's done 15 days. So but we're fine with revoking the balance, commuted to time served. Ms.
Did she
Harris,
do anything at all, Mr. Howard?
Judge, I don't believe she was able to get any of the conditions done. Ms. Carter had a significant loss in her life. We talked quite a bit of time about that the other day. She lost her daughter and it sort of sent her into sort of a tailspin. And she's had difficulty navigating that loss. And so it's been difficult for her to keep up with a number of things. But so no, Judge, she wasn't able to complete the requirements. And she's at this point just looking to try and put things back together and to engage in counseling and things that might help her to be able to get through the grief of dealing with the loss of her daughter. But we would ask the court, the offer we received from Ms. Allen was for revoke 30 days, which she's done 15 days, which means it will be a time served case. But if the state would like to term it as revoke the balance, that's fine, as long as it commutes to time served.
Officer Harris?
Yes, Your Honor, I don't have a problem with that. Give her credit for the 15 days in the closer case.
Okay. That's what we'll do.
Thank you, Judge.
Good luck to you, Ms. Carter.
Thank you, Your Honor. Thank you.
Position number 13, Mr. Howard.
Excuse me, this is, Mr. Sylvester Kennedy. Ms. McLeod still on, so we can do a breakout session?
This week she had the good part and just more for the team.
It's my understanding that she's in Judge Morrison's courtroom at the present time and that she will return when she completes reporting to Judge Morrison. So
Okay, thank
come back?
you.
Mhm. So who do we have next?
Position number 13, Mr. Howard.
What's the announcement on Mr. Howard? Is Ms. Adams with us?
I'm sorry, Judge Morrow.
They've announced that they have Mr. Howard, position number 13. I was wondering if Ms. Adams is ready for position 13.
She was talking to her client.
Oh, okay.
Mr. Howard, you said, Your Honor? I believe I am. I believe I spoke with her. Yes, I am ready when the court is ready, but I
Okay.
wasn't speaking with you.
That's fine. What's the announcement on Mr. Howard?
One moment, Judge, I'll put people over here. One moment, Your Honor.
Okay.
Your Honor, with regards to Mr. Howard, I didn't want to speak with the state.
Okay.
The victim is not on, Your Honor. Can we reset him? The reason is because there is a big issue with regards to Mr. Howard. He's not the actual person that, they're the wrong person. Mr. Howard is a junior. The person that was initially arrested for this incident was his father. His father has since passed away. And his father is actually the defendant, supposed to be the defendant, not the person that's before you.
When would you like to reset it until?
Next week, Your Honor, just so I can get the complaining witness on the line so that she can confirm the identity of the, or until the state, unless the state can get the complaining witness on the line to confirm the identity of
Okay, so we'll reset it for next Tuesday, September 12th.
Thank you, Your Honor.
All right, we'll see you back, Mr. Howard. Who do we have next?
Probation calendar, positions 3 and 4. Mr. Caldwell.
Yes, good morning, Mr. Caldwell. I'm Judge Eric Morrow. This is the state probation revocation calendar. Do you agree to have your case heard by video this morning?
Yes, sir. Good morning.
Good morning, Mr. Caldwell. Yes, Officer Harris.
Your Honor, Mr. Caldwell was sentenced on July the 27th, 2022 to 12 months to complete the 24 domestic violence class. As of today, he has not provided us proof of those classes. He has 10 days remaining. Probation is recommendations to time serve his case and to close it.
We ask the court to follow that recommendation, Judge.
All right, time served. Good luck to you, Mr. Caldwell.
Thank you.
Your Honor.
Next, ACDC, Your Honor. We have position number 8 on the probation calendar, Ms. Croker.
Get it on my paper. All right.
Your Honor, before we go on, I just need to make an announcement for the court. Position number 13 is, not position 13. Position number 1, Mr. Adams Christopher, he's downtown. He's in downtown court.
Okay, so are you saying that he's not going to be with us today?
Yeah, he probably not, because he's he's downtown.
Okay.
Unless he can meet with you where you are.
Let's see, Miss Adams. Okay, I'll let her know when she returns. So now we are on probation, position 7 and 8, I believe. Position 8, Cassandra Coker. I have a Crocker for position 7 and a.
Yes, I'm sorry, Cassandra Crocker.
Okay, the names are spelled differently, but I take it that it's the same person. Good morning, Ms. Crocker. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Let's see, Officer Harris.
Yes, Your Honor. We have Miss Crocker. She is to complete the mental health court. I actually did speak with Judge Porter. I want to continue on her probation. Judge Porter has been handling her case due to the mental health program. So we already scheduled everything for her to possibly be released and to continue her to see Judge Porter on the 27th.
Okay. Good morning, Mr. Bartels. How are you?
Good morning. Good, Your Honor. How are you?
I'm doing well, thank you. This is your case?
Well, I'm handling it for today, Your Honor. I'm somewhat familiar with Ms. Crocker's history, and we would concur with that recommendation. Just to clarify, Ms. Crocker was or is being monitored by the MHC staff, but she's actually not an active participant. That was not a condition of her probation. The MHET was a condition of her probation, but Judge Porter wanted her to report to and be monitored by the MHC court. I would note, Judge, she's served on the trespass case. The allegation was she would not leave her mother's home at a senior living facility, and she served, as of today, a total of 64 days. That included 38 days when she was initially arrested. So, in retrospect, most likely it should have been a time served case, but I understand that Judge Porter does want to monitor that case. So my concern is that she's just already served 13 days on this most recent incarceration since August 24th. So again, my main concern is that she get out of jail. So if she can be released today, if that is a recommendation to continue on probation, then we would ask for that.
Okay, I think that is a recommendation, and I'll follow that recommendation, and anything further, I will let Judge Porter handle down the road, okay?
Very well. All right, thank you, Judge.
All right, good luck to you, Ms. Crocker.
Your Honor, I do have a question. Can we please make sure that we have the right address on file?
For you, is that?
Yeah,
your-
for myself.
Yeah,
Okay.
we can take care of that, Ms. Crocker.
Okay.
Yeah.
Okay.
Well, and Judge, she indicates that she believes that's why she did not make one court date, but we can resolve that as soon as she's out.
Okay, very good. All right. Yes, good luck to you, ma'am.
All right, thank you.
You're welcome.
Thank you, Judge. Can I be excused?
Yes, have a good day, Mr. Bartels. Good to
Thanks.
see you as always.
You too. Same here, Judge.
On the probation calendar, position 15, Mr. Willis.
Yes, good morning, Mr. Willis. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Officer Harris?
Your Honor, Mr. Willis was sentenced to probation on December 14, 2022 to 12 months to complete a drug and alcohol evaluation, random drug screens, and 30 hours of community service. As of today, Mr. Willis has not provided us proof of those or did any drug screens. He has 3 months, 17 days remaining. Probation recommendation is 2 times serve his case.
That's the court to follow that recommendation, Judge.
Okay, I'll follow the recommendation. Time served. Good luck to you, Mr. Willis.
Thank you.
You're welcome, sir.
Next, we have Your Honor, position 39, Natasha Wright.
And this is going to be an arraignment and a bond hearing.
Yes, Judge, we can waive formal arraignment. We filed the paperwork for that, Judge. Just need to address bond.
What is the current bond?
$2,500 good.
Currently 2,500, Judge.
Yes, is that?
Yes.
Thank you. Okay, let's see. I issued this bond back on August 21st. And yes, Mr. Walker, do you have the history?
I'm trying to pull it up. My Odyssey is acting up. I'm pulling it up right now. It has 14 cycles. I'm going through them. I'm showing a battery conviction in 2012. Probation violation in 2017. Simple battery family violence. I'm not showing a disposition on that. And then in 2023, she was convicted of forgery 3rd degree, along with, it was just forgery charges, and that's it. She was given a 5-year sentence on that. Then I'm showing another probation violation in 2023. And I'm showing a battery family violence conviction out of Fulton County, and that was May of this year. And then after that, I'm showing another probation violation, which brings us to this case. In this case, law enforcement was dispatched to Woodruff Park. They spoke to the victims, Mr. Terry Moore and Thomas Bogan. I'm sorry, that's Mrs. Terry Moore and Thomas Bogan. They advised that the defendant accosted them verbally and then turned physical, striking them both. We would ask that the bond remain as said based upon the defendant's criminal history, along with no further contact with the victims, Terry Moore and Thomas Bogan.
Mr. Howard?
Yes, Judge. Ms. Wright has been in custody 16 days. She's a lifelong Georgia resident. She attended Southside High School right here in the Metro Atlanta area. She was working as a security guard up until a few months ago. And most recently, she applied for a job as a housekeeper at Grady. So she's a woman of limited means and won't be able to post a bond as set. She does have 3 minor children, ages 16, 15, and 8, that she's concerned about. They're with her mother, who has health issues. Her mother has a seizure disorder and some other medical issues that she helps to care for. She knows that her mother had surgery a few weeks ago, heart surgery, to get fluid off of her heart. And she, is very active in helping to take care of her mother. So she's concerned about being continuously incarcerated, which will keep her from being able to help care for her mother as well. And Judge, we'd ask the court to allow her to sign her own bond in this case. I don't believe there's anything to indicate that she failed to appear for a court date. So we would ask the court to convert the $2,500 to a sign-on bond.
Does she have a place to reside, Mr. Howard?
She does. She resides with her mother and her children, Judge.
Okay. And do you have the bond, present bond, Mr. Howard? Or should I go through it?
It's 25. I do have it, Judge.
Okay, so I'll convert the good bonds to signature bonds through the jail. So $1,000 for both of the simple batteries and $500 for the possession and use drug-related objects. No further contact with Thomas Bogan and Terry Moore, and stay away from Woodruff Park, which is located at 91 Peachtree Street. No drugs, alcohol, weapons while out on bond.
Thank you, Judge.
All right. Good luck to you, Ms. Wright.
Thank you.
You're welcome.
Yeah, position number add-on 1, Mr. Garrett Keith.
I believe that's Ms. McLeod's case. I'm not sure if she's back from Judge Morrison.
Appreciate you.
Okay, so it doesn't appear that Ms. McLeod is with us, so we'll have to hold. Who else do we have? Is there anyone at ACDC that we can take?
Oh, there goes Ms. McLeod.
Oh, yeah, Ms. McLeod. Hi, good morning. Can you hear me, Ms. McLeod?
Yes, Your Honor, I can.
Yes, we have Mr. Keith Garrett with us. What are we doing with Mr. Garrett this morning? He's position 1 on the add-on calendar.
Your Honor, the court had agreed to a signature bond for him on conditions that he would go to live with his mom in Michigan. The bond order was actually executed and mom is here in town and she's also on the Zoom. Apparently, when she went to bond him out, she was told that there's a hold of Douglas County. So that threw a wrench into everything. So that is why we're here this morning, because that was a last minute thing. I knew nothing about that until over the weekend.
Okay, so what's the request of the court this morning in that regard?
The terms of the bond that he had was that he would be released to mom. But since there is a hold for him, I am thinking that it would have to be modified so he could be released to Douglas County. I don't see how else it could work.
Do you have any objection to that, Mr. Walker?
No, Your Honor. If we could add the contingency, if he is released to Douglas, he should be released to his mother or returned to Michigan. This was a case that was on the competency calendar, so I think there was some concern about where he would be residing and things of that nature.
That's correct. And
Okay.
mom came down from Michigan for him, from Lansing, Your Honor, but this all happened over the long weekend.
Okay, so once he's released from Douglas County, then our bond order should say that he will go with his mother to return
To Michigan.
to Michigan. Is that satisfactory with everyone?
Yes, Your Honor.
Okay, all right. So Ms. McLeod, if you can prepare that, we'll get it signed. Yes, Ms. Brown, thank you for being here today. And do you have any questions?
No, sir. I'm just ready to take them back and get them some mental health.
Okay.
They got a mental health program down in Michigan that they just started up for the mental patients. So I've got in the program as of last week.
Okay.
Before I got down here. So he is qualified. So I'm trying to get him in there.
Okay. All right.
Well, we can just include no further contact with the victim and stay away from their instant location.
That was in the other bond orders.
Okay, thank you.
Yeah.
Okay. All right.
And
Okay,
I apologize. I had to log off because I had to answer a calendar.
No, I understand. They informed the court. You're fine, Ms. McLeod. Okay. Good luck to you, Mr. Garrett. You also, Ms. Brown.
Thank you.
Welcome.
Yeah.
Next, we have, Your Honor, is position 11, Ms. Harris Hall.
This is an arraignment and a bond modification. Is Ms. Adams on the phone?
She's coming, Judge.
Okay.
Talking with a client.
Thank you, Judge. Ms. Hall is going to be an arraignment in a bond hearing.
Okay, good morning, Ms. Hall. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, good morning, Your Honor.
Good morning, ma'am. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. Ms. Hall, you've been charged in case 23 CR 005277A with battery. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
Yes, Your Honor.
How do you plead, Ms. Hall, guilty or not guilty?
Guilty, Your Honor.
Ms. Adams?
I thought that you wanted to plead not guilty, Ms. Hall.
We spoke about the signature bond, ma'am?
Yes.
Yes, ma'am.
So to not guilty.
I want to plead guilty.
You change your mind?
Yes, ma'am.
Your Honor, we're gonna have to reset Ms. Hall because we discussed something different.
Well, what we discussed yesterday, I'm not really understanding, but if that's what we discussed yesterday, not guilty, then yes, ma'am, that's, you were telling me I could get out on a signature.
So why don't, I'm happy to give you the opportunity to, Ms. Hall, I don't want you to, this is being live streamed on YouTube. I'm happy to give you the opportunity to speak with your lawyer in private if you would like to do that, but I don't.
No, I want to proceed, Your Honor, with what we spoke about yesterday.
Your Honor, this may be appropriate for a reset. The state's recommendation is 12 months to serve 365 days. So I don't think the defendant's going to be prejudiced by postponing.
And I'm in agreement with you, Mr. Pilon. So I'm happy to reset it, Ms. Adams, if that's what you want the court to do.
My concern is that she didn't understand what we talked about yesterday.
And that's my concern also. So that's why I want to give you the opportunity to speak with her so that you can adequately explain to her the state's position and where you are.
I think we're in agreement. I understand, Ms. Hall, that you want to move forward, but it's really important that you're able to, that you understand what's going on, okay? So,
I understand what's going on, ma'am.
But I mean, with regards to how we proceed.
I'm sorry?
You stated that you didn't understand what we talked about yesterday as far as proceeding, correct?
No, ma'am, I understand. We talked about a signature bond yesterday.
Yes. Do you still
Yes.
want to try to get a signature bond?
Yes,
You know what a signature bond is?
yes, ma'am, where I sign myself.
All right, Your Honor, we'll go ahead and proceed.
Okay, well, we didn't get through the arraignment, so
Yes, Your Honor.
I don't think she understands that the process would be that if she pled not guilty, then I would consider her a bond modification.
Yes, Your Honor.
And she's not guaranteed of getting a signature bond because I don't know anything about the case as of yet.
Understood, Your Honor.
So how would you like me to proceed, Ms.
We'll go
Adams?
ahead, we'll go ahead.
My last question to Ms. Hall was, how do you plead, guilty or not guilty?
She's not guilty.
Okay, and that's how you're pleading, not guilty?
Yes, sir.
Okay, I'll record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Okay, what is the current bond? Do we have that, Ms. Strong?
Your Honor, our current bond is a $5,000 surety bond.
Okay, did we ever get anyone on from pretrial?
I asked,
I went ahead and pulled it since I knew that was an issue, Your Honor.
Okay. Thank you, Mr. Pilon. Do you have the history for me?
I do. There's 9 cycles out of Georgia, 1 cycle out of Florida. There's 3 convictions in 2017. One of those is a sexual offense. The other offenses involving deception. There are 2 convictions out of 2021. One is a non-fingerprintable offense that was amended down from a DUI. The other is a probation violation. And then there's a conviction out of 2022, which was false information to a law enforcement officer. And then there's this case, Your Honor. The 1 cycle out of Florida was driving without a valid license.
Okay, and what does this involve?
Your Honor, in this matter, officers responded to a dispute call. There appeared to be argument between the defendant and victim over housing or payment for work. And the defendant sprayed the victim with pepper spray in the face, and the victim is a juvenile. The victim was also arrested for aggravated assault, but that is the basis of the arrest.
Yes, Your Honor. With regard to that, my client did in fact call the police because the complaining witness was shooting at her. She did not see the police. And
I'm sorry, Ms. Adams, I'm having difficulty understanding you.
can you hear me okay now, Judge?
Okay,
Okay, sorry about that. Yes, Your Honor. Based on what's also included in the police report, and based on some information I received from my client actually is the one that called the police because the complaining witness was shooting at her. That's the reason why that's part of the altercation. That's how the police were called. In addition to that, she didn't see the police while he was chasing her with the gun, and that's when she turned around to defend herself. So with regards to that, Your Honor, in addition to that, rather, aside from the fact that her bond is $5,000, Your Honor, my client is gainfully employed. She is a bartender and server at Kirk Yard, which is a restaurant. She recently lost a 2-year-old baby just a couple months ago. So being in jail is not really a good place for her mentally while she's trying to grieve the loss of her child. Your Honor, we are requesting, we do understand that she does have some history. We are requesting that that she receive a signature bond, or at least her bond be lowered. In addition to that, Your Honor, Ms. Hall is willing to wear an ankle monitor, just so she can get out of ACDC.
how long has she been in?
She's been in jail she's been in ACDC for about 3 or 4 days, Your Honor, but she was originally arrested 17 days ago. So she spent about 7 days at East Point, 5 days at Rice Street, because she was in holding, and then 3 days at ACDC.
And the recommendation from the state is 12 months to serve.
That's correct, Your Honor.
Okay, Ms. Adams, what I think I want to do is at this time, I want to leave the bond where it is, but I do want you to speak with your client, and I would like for you maybe to discuss with her a possible non-negotiated plea, if that's something that you all would like to do. And I want to make sure that she understands, because I'm not certain that she did. Unfortunately, I will not be here on the calendars next week. If you would like to reset it for a time that I will be here, it will be in 2 weeks. So I'm willing to reconsider at that point in time, once I know that you've adequately communicated with her. Okay. Let's see, Mr. Jordan, are you with me, or Miss Grace?
Yes, Judge, I'm here.
When is I know I'm not here on Thursday or next week for SAP. Do you have?
The 19th is the following Tuesday after the 12th. Will you be here?
Yes, I'll be here on that calendar for the 19th. So let's reset this for the 19th. Is that agreeable with you, Miss Adams?
Yes, Your Honor.
Okay. All right. So I'll see you back, Miss Hall.
Thank you.
Position number 12, Ms. Juanisha Hightower.
Hey, Ms. Milton. Let's rotate. This is gonna be add-on position number 2, Ms. Willis.
Is Ms. McLeod on yet, so we can do the breakout session with position number 35?
Okay, Ms. McLeod, are you there?
I am, Your Honor.
Okay, where do you want me to go?
Medical.
Okay, and this is who do we have in medical?
This is the breakout session for Ms. McLeod, Mr. Kennedy.
I'm sorry, I can't understand you.
This is the person we're trying to do the breakout session with, Ms. McLeod.
Oh, okay. So, and what's his name?
Mr. Kennedy. Sylvester.
Okay.
Position number 35.
So we need to put medical and Ms. McLeod into a breakout room.
Okay, Judge.
Okay, thank you, Ms. Grace.
Thank you.
Okay, so where can the court go next?
Position number 2 on the add-on, Your Honor.
Okay, and what are we doing with Ms. Willis?
Your Honor, this is going to be a not guilty plea with bond hearing.
Okay, yes, good morning, Ms. Willis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
I apologize.
Yes, Your Honor.
Mr. Jordan attached this, but it looked like this bond was just supposed to be.
Yeah, it looks like she has a signature bond already. I'm working to verify that.
She does.
Does she?
Okay, yeah, it's a amended order. I have $3,000 signature bond through the jail.
And I believe that she's going to be in our mental health court. It looks like she has a court date this Thursday with Judge Kirk.
Correct. So I think they were just supposed to be amending the person that she's supposed to be released to. She's not supposed to be taken off leave today. Initially, she was supposed to be released to her mother. So this bond order should have a new person for her to be released.
No, it doesn't have any. It's just signature bond through the jail. It doesn't indicate that she's to be released to anyone.
I'm sorry, Your Honor, I didn't hear the last thing that you said.
The bond order that I have is just a signature bond through the jail. It does not indicate that she is to be released to anyone particular.
Can I release myself on this?
Is Mr. Howard still on here?
Mr. Howard?
Sorry, yes, Judge.
Do you know anything about Miss Tamara Willis's case?
Oh, yes, Judge. She was supposed to be released to her mother. However, I think there may have been her mother had some problems getting to Atlanta to pick her up. So we will need to figure out, I'll see if I can try and reach a number for her mother to see if she's been able to make other arrangements or when she anticipates she'll be able to get here. Because she was supposed to be here, I believe, on yesterday to pick her up, or Sunday actually to pick her up. So I didn't, Mr. Jordan, I think just got notice yesterday that she didn't make it. So it was put back on so we could try to readdress it. So if I can, I'll see if I can reach out to someone to figure out if she's coming or if someone else is coming, but the intent was for her to be released to one of those, a parent or someone like that. So they're from Florida, yeah.
Okay, so you just like for me to hold for Miss Willis?
Yes.
Okay. Okay, so we'll come back to Miss Willis. Who do we have next?
Position 12, Miss Juanisha Hightower.
And this is going to be an arraignment in the bond hearing.
Yes, Your Honor.
Yes, good morning, Ms. Hightower. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Ms. Hightower. You've been charged in case 23 CR 005135Y with criminal trespass. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
Yes, Your Honor.
How do you plead, Ms. Hightower? Guilty or not guilty?
Guilty.
Okay, it's my understanding that you're going to plead not guilty today.
Guilty.
So you're pleading not guilty, Ms. Hightower?
Yes.
Okay. Do you need to speak with your counsel?
Yeah. No, what are we supposed to be doing? We're supposed to be getting SOB. I'm supposed to be getting SOB.
Your
Okay.
Honor,
So,
he understands what's going on. I think the confusion comes from if she's not able to get the signature.
Yeah.
She's gonna take a plea. But as it stands at this moment, she has expressed to me that she would like to plead not guilty and for me to try to get a signature bond.
okay. So you're pleading not guilty, Ms. Hightower, is that right?
Yes, Your Honor.
Okay. I'll record your not guilty plea. Your case will be returned to the division judge and you'll get notice of your next hearing date. What is the current bond?
Current bond on this matter, Your Honor, is $1,500 surety bond, but I'll note for the court, there's also an open armed robbery case where she also has a surety bond, and that amount is $18,000.
Yes, Ms. Adams.
Your Honor, with regards to Ms. Hightower, she has been at ATBC for 16 days. She does have that open charge. However, she's my understanding that she's actually she's out on bond on that armed robbery charge. She was born and raised right here in Atlanta. Her whole family is here, so she has ties to the community. She has 4 children, ages 14, 12, 10, and 9. She, her education, she's graduated high school. She has a cosmetology license, and she's also a technical nurse at Grady. I'm sorry, a technical nurse assistant at Grady Hospital. Although she doesn't have a car or anything like that, she does work hard so that she can try to take care of her children. And so with regards to that, Your Honor, we're asking that she be released on the signature bond. She has absolutely no desire and no intention to ever return back to the incident location, regardless of the outcome of this case.
Your Honor, if I may make a brief argument to the court.
Yes, go ahead, Mr. Peeline.
This case was originally assigned a $10,000 surety bond. Then the state recommended that it only be a $1,500 surety bond. The reason for that, Your Honor, is that she has 3 cases from 2022. 2 of those were pled at the same time, but there was one subsequent to that. All of them were criminal trespass, all of them at this location, and all of them had a stay away provision. So I'm just trying to get this property owner some relief.
Okay. Anything further, Ms. Adams?
Your Honor, again, we just I'd like to reiterate that after having a very, very detailed discussion with Ms. Hightower, that she has no intentions on going back there. She has absolutely no intentions on going back there because of the issues that she's had at that place.
And I point out she's told the court that twice.
Right. I'm not inclined at this point in time, Ms. Adams, to modify that bond. The court's going to leave it where it is.
Okay, well, with regard to that, then, Your Honor, we're going to go ahead and change her plea to guilty.
Okay. Is that what you want to do, Ms. Hightower?
Yes.
Okay. Anything further from counsel?
No, Your Honor, we just asked the court to accept the plea as negotiated.
Ms. Hightower, it's my understanding that in case 23 CR 005135Y, you wish to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea, Ms. Hightower. The sentence is 12 months to serve, 26 days, credit for time served, 13 days, balance suspended, and stay away from where, Mr. Peeline?
The incident location is 911 Joseph E. Boone Boulevard, Northwest, Your Honor.
You understand you cannot go back to that location, correct, Ms. Hightower?
Yes, Your Honor, I understand. Thank you.
All right. Good luck to you, ma'am.
Thank you. Thank you, Ms. Adams.
Who do we have next?
Position number 35, Mr. McLeod, client.
I'm sorry, tell me the name again.
This is Sylvester, position number 35.
35, okay. What are we doing, Mr. Sylvester, Ms. McLeod?
Your Honor, I wanted to ask the court to give him a different bond, Your Honor, signature bond. He does have a bond, but he's not in a position to post the bond that he has.
Okay, does he need to be arraigned this morning?
Yes, Your Honor.
Okay, let's do that first. Yes, good morning, Mr. Sylvester. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you, Mr. Sylvester. You've been charged in case 23 CR 005107E with simple battery. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. McLeod?
I do, Your Honor.
How do you plead, Mr. Sylvester? Guilty or not guilty?
Not guilty.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. I take it that there's a history. Ms. Jackson, good morning. Thank you for being here this
Good
morning.
morning, Your Honor. If you would just bear with pretrial because I was assigned here at the last minute. So I will go through the record real quick, please.
Okay, thank you. I appreciate it, Ms. Jackson. And while she's doing that, Mr. Walker, can you just give me the facts of this case?
Yes, Your Honor. In this case, law enforcement was dispatched to the incident location. They spoke with the victim, the other party, Miss Wanda Jones. She advised that her and the defendant were in a verbal altercation, at which time he did push her to the ground and hold her down. The defendant's nephew actually was there on the scene, and he did observe the defendant holding the victim down. I will let the court know that this was dual arrest. However, we do believe that this party was also an aggressor in this instance. So we ask that the bond remain set as it's $1,000 surety and no contact with the victim, Ms. Wanda Jones. And the incident location is 3787 MLK Drive.
Okay, thank you. Do you have that history for me, Ms. Jackson?
Yes, Your Honor. The defendant has 19 cycles. The last arrest was May the 31st, 2022, and that was in Mobile County, Alabama, for assault in the 3rd degree. I'm gonna just scroll through the GCIC real quick for the court, Your Honor, to check and see if there are any convictions for you.
Okay.
There's a real old felony conviction that was in 1998 out of Alabama for possession of forged instruments. I'm still scrolling through just to let the courts know.
Okay.
You see an additional appear to be an additional felony conviction that was in 1992 for theft by receiving stolen property. And let me switch it. It's going to, I think it's going into Georgia now. Just check and see if there are any convictions in Georgia. See a felony conviction out of Douglas County that was in 2008 for forgery in the 1st degree. See an additional felony conviction that was in 2007 out of Fulton County for aggravated assault, false imprisonment, and possession of a firearm during commission of a felony. See a misdemeanor conviction that was in 2006 for disorderly conduct. An additional felony. I do see an additional felony conviction that was in 2005 out of Cobb County for Terroristic Threats Act. Nothing in addition, Your Honor.
Okay, thank you. Mr. Walker, and the recommendation is 12 months to serve?
There was a firearm involved in this altercation, Your Honor.
But my client was not the one who had the firearm.
That is correct.
Okay. Yes, Ms. McLeod.
My client is 64 years old, Your Honor. He tells me that he is a veteran. He's currently disabled. He was disabled on his job, and he lives in veterans housing, which he is very concerned that he may lose. He tells me that he does voluntary work with homeless people, and that the alleged victim is someone he met in the course of his volunteer work that he does. They're not in a relationship or anything, and there are no allegations that they are. He said she came to his house on the date of the incident and asked if she could take a shower, which she agreed to. She had come there with someone else, another male, and he agreed that she could take a shower at his house. And she started a verbal altercation with him, Your Honor, and then she attacked him. She actually was arrested, and I believe she was charged with a felony. She had a gun in her possession, and she was the one who attacked my client. My client recently had a heart attack in the past month, Your Honor, and he has several health issues that he's dealing with at the moment. He also tells me that he is currently enrolled as a student at Atlanta Area Tech, and he's concerned about his status since he's been locked up now for approximately 3 weeks. He does have $1,000 bond, Your Honor, but he's not in a position to post that bond because he tells me that he doesn't have access to his debit card. He probably could, if he could access his money, but he doesn't have anyone. He's unmarried and he doesn't have any children. No one to help him. So I would ask the court to consider giving him a signature bond. Your Honor, I know that pretrial has said there have been some felonies, but they were a long time ago, and he is 64 years old right now. Nothing further, Your Honor.
Okay, Ms. McLeod, if you can take the modification down for the court, it's going to be a $5,000 signature bond through the jail. No further contact with Wanda Jones. Stay away from the 3787 MLK Drive address. No drugs.
I believe that's his apartment, Your Honor. She doesn't live there.
Oh, okay. Well, no further contact and no drugs, alcohol, or weapons while out on bond.
Yes, Your Honor. Thank you.
All right. Good luck to you, Mr. Sylvester.
Position 20, Your Honor, Mr. Jones.
Okay. Huh? Yes, signature through the jail. And this is going to be an arraignment also.
I'm so sorry, Your Honor. I didn't hear which position.
This is position 20, Ernest Jones, I believe.
Yes, Your Honor. This is going to be an arraignment.
Good morning, Mr. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Can you unmute therefore? Speak up.
Yes.
Okay, thank you, Mr. Jones. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Mr. Jones, you've been charged in case 23 CR 005121F with theft by receiving stolen property. This charge carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Ms. Adams?
Give one moment, Your Honor. Yes, Your Honor. Thank you. With regards to Mr. Jones.
I'm sorry, Ms. Adams. My question was, do you waive formal reading of the accusation?
Yes, Your Honor, we waive.
How do you plead, Mr. Jones? Guilty or not guilty?
I guess.
And we will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. What's the current bond?
I see it as being $3,000, Your Honor.
Say it again.
I see it as being $3,000, Your Honor.
Okay. Is there a history, Ms. Jackson?
Your Honor, I'm gonna need a few minutes on all records. I'm not prepared because the schedule was changed at the last minute.
Okay,
I'm looking at right
you're
now.
fine, You're fine, Ms. Jackson.
Okay,
Do you have the history, Mr. Pilon?
I can read it just as fast as pretrial can, Your Honor. I don't have it already prepared.
Okay.
but I am already in the case. He has 5 cycles. I can tell Your Honor that he's also in an armed battery charge. He has, so obviously the armed robbery charge is 1 cycle. I apologize, Your Honor. So I show he was arrested for armed robbery January of this year. He was subsequently arrested for aggravated assault May of this year. Prior to that, I apologize. There's also a 2019 rape arrest. Prior to that, there's not much.
Okay. Ms. Adams?
Yes, Your Honor. With regards to his open felonies, and speaking with Mr. Jones, he did recently have court. He informed me that there have been some changes to those charges. Those charges are supposed to have been amended, but I didn't see it in the system. But they were supposed to be knocked down to what appeared to be misdemeanors based on what the information that he gave me. Aside from that, I do see, I believe he may have a hold out of another county. But other than that, Mr. Jones has a 10th grade education. He was gainfully employed at Little Caesars. He was working on getting his driver's license. He does music and art. He also has a small child. The baby is only 2 months old. So since he's been in here, he now has a baby that he has never had the opportunity to meet. Your Honor, with regards to that, we are requesting a signature bond for Mr. Jones. So that way he can also go and handle the foreign warrant, the hold that he has in there.
Okay, I gave him this bond back on August 21st, a $3,000 good bond. I don't see that the circumstances have changed as such. And given his history, I think the bond was adequate. Good luck to you, Mr. Jones. Who do we have next?
Position number 40, Mr. White.
Aye.
And this is going to be a non-negotiated plea.
Your Honor, I believe it'll be negotiated.
Okay.
The defendant has been in 77 days, I believe. We can do time served, balance suspended. No further violation of Georgia law.
That'll be fine. That's what we were gonna be asking for.
Okay. Good morning, Mr. Weiss. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. Anything further, Mr. Walker?
Nothing from the state, Your Honor.
Mr. Howard?
Nothing further, Judge.
Mr. Weiss, it's my understanding that in case 23 CR 003849G, you wish to plead guilty to willful obstruction of a law enforcement officer. Is that correct?
Sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? Is that a yes?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Weiss. Good luck to you.
All right.
You're welcome.
Thank you, Judge.
Honor, can we revisit position number 4 and number 5, Mr. Barbers?
Okay. And where were we with Mr. Barbers?
Your Honor, he was originally a waiver, but then we changed his plea to a negotiated plea.
Okay. And what is the What is the negotiation?
The understanding that defense has, it was originally 12 months to serve 365 days, credit for 365. I believe he's actually served 209 days, but with the 2-for-1, he's served more than enough to get out. And it was supposed to be balanced, suspended, and I believe stay away, if I'm not mistaken.
Okay, Mr. Pilon?
That's correct, Your Honor.
All right. Mr. Barbers, it's my understanding that in case 22 CR 005590F, you wish to plead guilty to loitering and prowling and obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of, and you're still under oath, Mr. Barbers? Are you under the influence of any drugs or alcohol this morning?
No, sir, Judge.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Sir.
Has anyone forced or coerced you to plead guilty?
Sir.
I'll accept the plea as negotiated. Good luck to you, Mr. Barbers.
Thank you, Mr. Morrow.
Yes, you're welcome, sir. And position number 5 is going to be null pros, my understanding, Mr. Pilon.
That's correct, Your Honor.
I have Ms. Mitchell for probation, position 11 and 12.
And this is Ms. Mitchell.
Yes, sir.
Okay, good morning, Ms. Mitchell. I'm Judge Eric Mario. This is the probation revocation calendar. We're conducting by video. Do you agree to have your case heard by video?
How can I get?
Oh, hold on.
I'm sorry, is that a yes?
Yes, I do. Yes, sir.
Okay, thank you, Ms. Mitchell. Yes, Officer Harris.
Your Honor, Ms. Mitchell was sentenced on May 11th of this year to complete a shoplifting course. As of today, Ms. Mitchell has not reported to our office. She has about 287 days remaining. Probation recommendation is just to time serve her and to close her case.
And yes, Judge, we'd ask the court to accept that recommendation to close her case out.
Okay, time served, Ms. Mitchell. Good luck to you, ma'am.
Thank you so much. You have a blessed day.
You do the same, ma'am.
Your Honor, next we have position 8, Sylvia Fletcher.
Okay. This is going to be a negotiated plea.
Yes, Your Honor.
Again, my calendar shows that this has been transferred up to the DA's office.
Give me 1 second.
I received a recommendation on that. And it shouldn't have been for the court. That's why shoplifting for under $500.
Okay, so first, and let me clarify, we are back on the SAP calendar, correct?
Yes.
Okay, yeah, Ms. Shamika Adele, again, our file indicates that it's been transferred up for recidivism.
I'm sorry, I thought that we were doing with Sylvia Fletcher. Maybe we're talking about 2 different positions. Which position are we on?
This is position number 8. Is my understanding, Sylvia Fletcher. Theft by shoplifting charge.
That's right.
I have a recommendation from the state here.
I have it, Your Honor. Is it a negotiated plea?
Yes.
I can handle it.
Okay.
Okay, so is there, so no issues?
No issues. The recommendations, I didn't know if you wanted to clarify.
Yeah, the recommendation that I received was 12 months to serve 26 days, credit for 13 days, balance probated, take a theft course and stay away from.
That is great, Your Honor. I can give you that instant location in just a moment.
Okay. Good morning, Ms. Fletcher. I'm Judge Eric.
Good morning.
Good morning, ma'am. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Is that a yes?
Yes.
Okay, thank you, ma'am. Anything further, Ms. Adams?
I think further, Your Honor, we just asked the court to accept the plea as negotiated.
And as soon as you get that stairway location, let me know.
Yes,
Mr.
I'll
Coffey.
just a few more seconds.
Okay, Ms. Fletcher, it's my understanding that in case 19 CR 000427J, you wish to plead guilty to theft by shoplifting, is that correct?
Yes, sir. Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Ms.
No,
Fletcher.
sir.
Let's
And
see.
that-
you know- Go ahead, Mr. Walker.
That address is 595 Piedmont Ave. It's a Publix grocery store.
You understand you can't go back to that Publix?
Yes,
Ms. Fletcher?
sir.
Okay. Let's see, I am going to, once you complete the theft course,
Yes, sir.
I'm gonna have the probation terminate. So the sooner you complete that course, the sooner you're not gonna be on probation, okay?
Yes, sir. Yes, sir.
All right, good luck to you, Ms. Fletcher.
Thank you.
You're welcome.
Thank you, Your Honor.
Ms. Milton.
Officer Harris,
Hello. Yes, Your Honor.
we completed your cases for this morning?
Yes, I was just waiting for you to get done.
Okay, you have a good day.
You too. And are you gonna be in G33 this afternoon?
No, they're having traffic here this afternoon, but you can send them to me and I'll get them signed and back to you, okay?
Okay, thanks, Your Honor.
Okay, have a good day.
You too.
Your Honor, do we have any news on Ms. Willis, the add-on too?
Judge, yes, unfortunately, no, I've called the number that I had for a mother several times and have not gotten a response. So I would ask if we could put this on Thursday's SAP calendar to potentially readdress it. I'm hoping that the mother, she was trying to make arrangements for someone to come and pick her up, but we would need to know who that is. There were several family members on the line when we had first appearance the other day for support. So if we could put this on Thursday's SAP calendar so that we can figure out what's going on.
Okay, so that'll be reset until 9/7. We still have position, I think Ms. Adams, position number one, I was told that he's not available today, that he's in another court.
Oh, okay.
So if it's okay with you, we'll also reset this till Thursday, 9/7.
Okay. That's fine, Your Honor.
Okay, and let's see, we still have position 21, Jimmy McKinnon. Are we gonna have him today?
Your Honor, he was actually en route.
Okay. What about position 24, James Moss?
Your Honor, it was my understanding that there was a miscommunication with the jails, and so we need to reset Mr. Moss, position number 24.
Okay, when would you like to reset him until?
He can be reset to the next calendar, Your Honor.
Okay,
Yeah, Tuesday's fine.
okay. So 9/12,
That was Mr. Moore.
that was position number 24. What about position 37 and 38, Mr. Webb?
Yes, Judge. Mr. Webb, we waived his presence today. We were just wanted to quickly readdress or to address the bond. We believe it was an address issue that contributed to that. We just
And this was, he missed a court date with another,
Yes, he missed a few court dates, Your Honor, with Judge Besson. I have that he has a total of 3 FTAs, but the most recent one was on January 26th of this year. Of course, we would ask that at this point it's sent back to Judge Besson to make a final determination on the bond in association with that FTA amount. Again, this is his 3rd FTA for just this case.
and that's my practice, Mr. Howard, is if they've missed a court date with another judge and if they've issued a bond, that I send it, let them modify the bond if they choose to.
I understand, Judge. We haven't. Okay, we'll. I told him, I talked to them about that.
Okay, so we'll just send it back to Judge Besson for that modification.
And
But-
Judge, I do show positions 32 and 33. Mr. Armstrong is on for that case for a bond matter. Like, she can provide additional information about Judge Taylor's courtroom.
Yes,
Wait.
Judge, good morning.
32 and 33.
Yes, Judge, there's an amended announcement. I had neglected to indicate there would be the bond would need to be addressed, but I did notify Mr. Walker once I realized that it would be. And so Mr. Armstrong is on.
Okay, so do we have a waiver of Mr. Smith's appearance?
We do,
I
Judge.
can, yes.
Yeah, I did file that, Judge. Waiver of arraignment and presence. I did file that. Mr.
Okay. And let's see, what is the current bond?
On 32, I believe it's a $3,000 cash, and I believe it's a $3,000 cash on 33 as well. He does have a history, so I would ask for pretrial services to provide that to the court, please.
Sure, counsel, it's just gonna take me a few minutes. If the court would just give me a few minutes.
Yes,
have to go
yes.
through it.
And while she's looking, I do have some of his history. I'm showing that he has a 2018 conviction out of Mississippi for robbery. He received a 15-year sentence on that case. As the court is aware, he has 2 cases on today's calendar. The first case, 32, that happened in August 30th of 2022. The defendant also has an open felony matter with the same victim. That case number is 23 SC 186759. And that case is aggravated assault and possession of a firearm by a convicted felon. And in position 33, which happened about a month after the aggravated assault, that's another $3,000 cash bond with the same victim. Based on the circumstances, based upon him having 3 open cases with the same exact victim, several months apart, and one of them being a pending felony matter, which is the aggravated assault, we would ask that the bond remain as said. We feel as though a total of $6,000 surety $6,000 cash bond for both cases is more than generous. There's a great risk of reoffending. We have grave concern about the victim in this case. And with that being said, no circumstances have changed. So we would ask that any bond modifications would be denied, Your Honor.
Okay, Ms. Jackson, as soon as you are ready, let the court know. This is positions 32 and 33, Mr. Moore.
Oh, I'm sorry. Oh, just.
I'm sorry, were we waiting for pretrial or should I go forward?
Good morning, Ms. Armstrong.
Good morning.
Just a moment, please.
Of course. I just didn't want to stand here saying nothing when I should be saying something.
I understand. Okay. I would like to get his complete history first, Ms. Armstrong, so.
Of course.
Just for position number 32 is on from
Your Honor, I see a total of 4 cycles. Oh, I didn't write it down. I'm so sorry. He has a felony conviction out of Mississippi in 2017 for robbery, and I'm going back to it now so that I can give you the last arrest.
Okay.
Yeah.
Yes, that last arrest was December 28th, 2017, out of Pearl Police Department in Mississippi for robbery. And he was convicted on November 26th, 2018. Let me see if they listed the term for you. It said incarceration 15 years and 10 years suspended and 5 years of probation. And there are no other convictions listed in the GCIC, Your Honor.
Courtroom 2, would you mind muting for us, please? So he's got one conviction for robbery in 2017, 2018, and that's the only conviction?
That was the only conviction that was out of Mississippi for robbery.
Okay, and anything out of Georgia?
There was just one, there were 3 cycles out of Mississippi, and there was the one cycle out of Georgia. That appears to be the part of his current arrest. I'll go back into it for you.
Okay. And Mr. Walker was saying something about, and I'm sorry, Mr. Walker, the same, I've got a Jasmine Godfrey as the alleged victim in one of the cases.
In both of the cases on today's calendar and also in the felony case. That case number is 23 SC 186759. And I believe he's currently being held on that charge right now, but I can double check that. But that is correct, Your Honor.
Okay.
All right.
And that was the basis for us asking the bond not to be modified because he has reoffended 3 times with the same victim.
Okay.
Okay.
I apologize for interrupting. I'm sorry. That arrest that was out of Georgia was February 23rd, 2023 by the City of Atlanta Police Department for aggravated assault, burglary in the 1st degree, possession of a firearm by a convicted felon, possession of a firearm during commission of a felony, and criminal trespassing, and battery family violence, and simple battery family violence, an additional case of simple battery family violence, and misdemeanor theft by taking. There's no disposition for that arrest, so that's still pending, Your Honor.
And that is a no bond, Your Honor.
Okay, thank you. Yes, Ms. Armstrong.
Thank you, Judge. We're simply asking for a reasonable bond to be set in this matter. My client is entitled to that because he's been incarcerated since the day of his arrest on February 23rd of this year. I see that he has a $20,000 cash bond total. There are 2 additional misdemeanor cases that are pending. CP transfer numbers, they're transferred from Judge Taylor's courtroom. They've been transferred to DA's office. There are cash bonds associated with those. And I know that we're not here to litigate the bond on those today, but to paint the big picture here, it's not just the cash bond on the 2 cases before, Your Honor. It's $20,000 total. What I see is that he has a $10,000 cash bond on the 1749H matter, and then it is $3,000 cash on the 1049H matter. But once again, my client is entitled to a bond modification. We were asking for a surety bond to be set in the 1049H matter to the amount of $1,000 surety, and then for 1749H to no more than a $3,000 surety bond. And correct, he is being held on this felony matter without bond. So he's not going to get out anytime soon. It's just for the purpose of law, he's entitled to a bond reduction. He's been incarcerated. And of course, I need to note the dangerous conditions at the jail that I would ask Your Honor to consider in reducing the bond. I did speak with the alleged victim of this matter. She wants nothing to do with this case. It sounds like she's going to be moving out of state soon. There's been no allegations he's had any contact with her since, but she has sent money to his mother. And if he gets out, I do have an address to provide to the court where he can live locally. Thank you.
And if I could just clarify, on both of these cases, it's a $3,000 cash. I'm not sure where counsel is getting the $10,000 bond, but per the jail screen, it's $3,000 cash on both of these cases.
It's 10.
And yes, he is entitled to a
Say it
bond,
again.
and he has a bond.
So he has a.
I said he's entitled to a bond reduction because he's been in custody for a long time and he's indigent. He can't make the bond he has.
It is a cash bond on all of them. It's 3, 6, 7 on the. The 23 CR 001052. I'm not sure what that one is. That's a cash bond.
That's not on today's calendar, I don't believe.
Right, but I think she's counting all of them,
Fair
so.
enough.
To paint the big picture of what I ask is to the court, correct?
The 001-049 is a $3,000 cash bond, so he does have cash bond on all of his charges, all his misdemeanor charges in state court.
Okay. And he has a no bond on those others. I think that's the bigger picture. Miss Armstrong, if he gets a bond on those felony charges, I'm happy to hear your bond modification request at that time. So if he does get a bond on those charges, you can bring him back and I'll consider a bond modification on these at that time.
Yes, and just for the record, it's my understanding the felony attorney handling that matter did not file, or it looks like there hasn't been a bond motion filed in the felony matter. And when it appears that hasn't happened because there's been no reduction on our end. So I understand this is a unique situation where there's a lot of matters, and I still behoove the court to grant a reduction. My client's entitled to it by law.
Okay. Well, as I said, I will consider it if he gets a modification in the felony charges. I think he has bigger fish to fry at this point in time.
Understood.
Okay. All right. If nothing further, you have a good day.
Thank you so much. Good to see you.
You also, as always. And let's see, is position number 21, is he still en route? So let's go ahead. I see Mr. Mark Smith on the line. Can we go ahead and handle the DV bench warrant case? Who's representing Mr. Smith this morning?
Good morning, Your Honor. Attorney Challenger's here.
Yes, good morning, Ms. Challenger. Mr. Smith, good morning. Can you hear me okay, sir? You need to unmute yourself.
You have to unmute yourself, Mr. Smith. Your Honor, I think he's trying to figure it out.
I understand.
Okay, can you hear me now?
I can hear you, Mr. Smith. Good morning, sir.
Good morning.
Let's see, Mr. Walker, I take it that Mr. Smith missed a court date?
Yes, Your Honor. He missed the arraignment calendar in front of Judge Edline on August 1st of this year. Of course, it's the state's position, it's the defendant's responsibility to update their address and to make it to all court appearances. So we would ask that any bench warrants not be set aside. Thank you.
Ms. Challenger?
Yes, Your Honor. Your Honor, my client, he actually does live in the same address that the court has on file, my understanding. He actually just misplaced a notice, so he was unaware that he had a court date. Once he did become aware, he did call my office to hire me on, so I did file my entry. So any further court dates that he has, we will receive at the office, as well as he will receive, and we will make sure that he does show up to court. So having said that, I don't believe he has any other history. I don't think there's any other issues with this matter. He received a citation for this particular case, and we're actively fighting it. So I would just ask that you do set aside his bench warrant and then set him to the next arraignment calendar, so that way we can take care of it.
Okay, Mr. Smith, it's this court's practice that I'll give you one chance. I will set aside the bench warrant today, but if you miss any more court dates, then it won't be set aside in the future. You understand?
Yes, sir.
Okay, so your case is going to be returned to the division judge, Ms. Challenger, so he'll get notification from apparently Judge Edline regarding his next hearing date. If you could prepare that set aside for the court, we'll get it signed.
Okay, Your Honor, do I have an email that I need to provide it to, or?
Yes, if you'll provide it to Casey Strong, who is in the chat.
Okay, I'll send her.
Okay.
All right, I think that completes our business. Once I get that email made, myself and my client be excused.
Yes, you all have a good day.
All right, you too. Good seeing you tomorrow.
Thank you.
Yes.
Thank you.
Okay, let's see. Courtroom 2. Are we going to be able to see Mr. McKinnon today or not?
I'm gonna have to reset Mr. McKinnon, Your Honor. Mr. McKinnon was brought downtown by mistake.
Okay, all right. So was this going to be a plea?
Your Honor, I needed to clarify that with Mr. McKinnon. That's why I wrote hold for announcement, because I just needed to clarify that with him. So,
Okay, all right. I'm just wondering when we should reset this to. I don't want fees.
so Mr. McKinnon, it's kind of unclear. I can't tell in Odyssey. I don't know if the state can help, but he has like $60,000 bond because he's got some pending felonies. Deputy said that he was informed that he may have been bonded out on those, but I couldn't see that in Odyssey, so it's unclear. But he also had a hold in juvenile court. So I don't know what the status of that case is. So
Okay, well, I'm happy to give you time to figure that out, Ms. Adams. I just want to know when we're going to reset him for this morning.
the 12th is fine, Your Honor.
Say it again.
12th is fine, Your Honor.
Okay, thank you. So 9/12, so next Tuesday, and hopefully that'll give you enough time to speak with the state regarding those matters. Do we have anyone else that we need to address this morning?
Thanks, Tom.
I think that takes.
Yeah, I do have a question. I sent a chat to Mr. Howard. I didn't hear whether or not what the status is for Miss Tamaria Willis. She did request somebody contact her dad.
That was reset until September 7th.
Okay, thank you.
Okay, and I think that takes care of everyone on the calendar. So, and Ms. Strong is ready. We can go over the calendar if you all like.
It's ready, Your Honor.
Position number 1 is reset for September the 7th SAP calendar. Position number 2 and 3 are also reset for September the 7th SAP calendar. Position number 4 was a negotiated plea. Position number 5 was null pros. Position number 6, 7, and 8 were negotiated pleas. Position number 9 was a negotiated plea. Position number 10 was an amended bond, $3,000 signature bond through the jail, with a no further contact and no drugs, alcohol, weapons, or firearms. Position number 11 was arraigned, but it will be reset for September the 19th SAP calendar. Position number 12 was a negotiated plea. Position number 13 will be reset for September the 12th SAP calendar. Position number 14 was reset jail jury. Position number 15 was reset jail jury. Position number 16 and 17 and 18 and 19 were all reset for September the 12th SAP calendar. Position number 20 was arraigned reset jail jury. Position number 21 was reset for September the 12th SAP calendar. Position number 22 was a negotiated plea. Position number 23 was null pros. Position number 24 was reset for September the 12th SAP calendar. Position number 25 was an amended bond, $3,000 signature bond through the jail with a stay away and no drugs, alcohol, or weapons. Position number 26 was a negotiated plea. Position number 27 was null pros. Position number 28 was reset jail jury. Position number 29 was reset jail jury. 30 and 31 were also reset jail jury. 32 and 33 were reset jail jury. Position number 34 was reset jail jury. Position number 35 was an amended bond with a $5,000 signature bond through the jail with a no further contact. Position number 36 was a non-negotiated plea. Position number 37 was reset jail jury. 38 was reset jail jury. Position number 39 was an amended bond, $2,500 signature bond through the jail with a no further contact, stay away, and no drugs, alcohol, or weapons. And position number 40 was a negotiated plea. On the add-on calendar, I apologize. What did we do with Mr. Garrett? I have an amended bond order, but did we have an amount?
That was Ms. McLeod's case.
Yes, Your Honor. There was an amount set for bond, and the change was that he would go to Douglas County and then he would be released back to his mother. At least that was my understanding.
So their bond amount was the same, correct?
Yes, 7,500 signature bond.
And to be released to Douglas County?
Yes.
Thank you.
You're welcome.
And position number 2 on the add-on calendar was reset for Thursday's SAP calendar.
Okay, questions, concerns? All right, thank you all. I appreciate it as always. Have a good rest of your day.
Thank you for your patience, Your Honor.
Yes, thank you, Ms. Jackson. We appreciate it.